Is Jenny Hansen. I am the Oregon Attorney General Communications Director, and I will be moderating today's press conference. We are announcing some new legal action today against the Trump administration. I'm sure you probably saw our news release that went out a short time ago. We have the four attorneys general who are leading the case on this Zoom call. Each attorney general will make some brief remarks before we open it up for questions. Before we begin, we have some housekeeping notes. Reporters, if you could turn off your cameras during this call and also have your microphones muted. Now, when we do get to the Q&A to ask a question, of course, you can unmute yourself. And then please use the raise hand feature. And if you could identify the outlet you were with as well. And I will call on a collection of you as time permits. So today, you are going to be hearing from Oregon Attorney General Dan Rayfield, Arizona Attorney General Chris Mays, California Attorney General Rob Bonta, and New York Attorney General Letitia James. So we're going to kick things off with Oregon Attorney General Dan Rayfield.
Well, good morning, everybody. First, we just want to thank everybody for being here. This morning, a coalition of 24 states led by Oregon, Arizona, California, and New York filed our second lawsuit to stop President Trump's unconstitutional tariffs. Almost 2 weeks ago, the president learned what all of us already knew, that his attempt to pass tariffs were unlawful and unconstitutional. And instead of focusing his efforts on returning the hundreds of billions of dollars to Americans, he instructed his attorneys to find more lawyerly ways to pass his failed economic agenda item. Under his instruction, his administration is implementing tariffs under Section 122 of the Trade Act of 1974. And just like his prior tariff lawsuit that he lost, no president has ever used this statute to implement tariffs. In fact, this statute has never been used at all, ever in the history of our country. This is a statute that was passed in 1974 that was intended to respond to an economic condition that can only occur when a country is on a fixed exchange, like the U.S. was when we were on the gold standard. It is an archaic statute that was never intended for its current purpose as used by the Trump administration. During the past year, Trump could have found many various legal ways to pass his economic agenda. If he had the support of Congress, he could have legally passed his tariffs by now. He certainly found time to pass legislation like H.R. 1 that removes healthcare benefits and strips food assistance away from Americans. But the truth is, he doesn't have the support of Congress, and nor does he have the support of the American people, and he is doing an end run. Make no mistake about it, President Trump's signature economic policy is historically unpopular and is costing Americans, our businesses, and us as states hundreds of billions of dollars. The Trump administration continues to brag about taking in close to $200 billion of tariff revenue. At the same time, recently, the Federal Reserve Bank of New York issued a report concluding that Americans, not foreign countries or companies, are paying for 87% of his unlawful tariffs. This has been unquestionably the largest tax increase on Americans without congressional approval. And it cannot continue just because a few of Trump's lawyers have found a way to twist words and craft a legal argument. If the Trump administration took the time to listen to Oregonians, these are the type of things that he would hear. He would hear from our restaurants who are purchasing certain food items that can't be made in the United States, and those costs are passed down to us as consumers. He would talk to our retailers that hear and need component parts for the products they're selling to Oregonians. Again, passing those costs down to Oregonians. He would talk to a local chocolate manufacturer, the very types of jobs that President Trump claims to want to incentivize. And he would hear that the manufacturing equipment and cacao that has to be purchased outside the United States has gone up, impacting their business. He would hear from local pharmacies that have fixed reimbursement rates. Again, with medical supplies increasing, it is causing layoffs. He would hear from our agricultural industry and our nursery industry, where his tariff policies are destroying trade relationships with Canada, relationships that have existed for more than multiple decades. In the conversations we've had over the last year, there is one specific conversation with a small business that has stood out for me. And this is what he said. The challenges of COVID were easier to manage than the chaos of Trump's tariff policy. We are all proud to be a part of such a large coalition fighting to keep the cost of living down for Americans. As attorneys general for all of these states, we will be working incredibly fast and as quick as possible to get in front of a judge to stop these unlawful tariff policies.
Okay, up next we have Arizona Attorney General Chris Mays.
Thank you. Yes. Hi, I'm Attorney General Chris Mays from Arizona. 2 weeks ago, the Supreme Court of the United States told Donald Trump that his tariffs were illegal, that he had been taxing the American people without the legal authority to do so, that he had to stop. So what did he do? He threw a temper tantrum, and he did it again. Rather than accepting that ruling, the president immediately turned to a different law, one that has never been used to impose tariffs in American history. In fact, it has never been used at all, and slapped a 15% tariff on goods from most countries worldwide. He's calling it a fix. It is not. It is the same illegal power grab under a different statute than he used the last time. Section 122, as my colleague mentioned, of the Trade Act of 1974 authorizes tariffs only in very specific, narrow, limited circumstances, including when there are, and I'm quoting the law directly here, large and serious balance of payments deficits. A trade deficit is not a balance of payments deficit. These are not the same thing at all. The president either doesn't know the difference or he doesn't care. Either way, he is breaking the law again. Today, I am very proud to stand with Oregon AG Dan Rayfield, California Attorney General Rob Bonta, and New York Attorney General Tish James, and attorneys general from across this country representing both Republicans and Democrats and independents in filing suit to stop these tariffs. Because here is what is at stake for Arizona families. Researchers at the Federal Reserve Bank of New York found that nearly 90% of the cost of Trump's tariffs are paid for by American consumers and businesses, not foreign countries, not foreign manufacturers, but us, residents of all of our states and Americans across this country. Trump's IEEPA tariffs cost Arizona an estimated $1.6 billion. Nationwide, a 10% universal tariff costs the average American household over $1,200 a year. His 15% tariff would push that even higher. That is money out of the pockets of Arizona families trying to buy groceries, pay rent, and keep their small businesses afloat. Donald Trump does not have the constitutional authority to tax the American people on his own. Congress holds that power exclusively. The Court of International Trade, the Appeals Court, and the Supreme Court have all said that. These tariffs are unlawful. They are harmful, and we are going to stop them again. Thank you.
Thank you. Speaking next, California Attorney General Rob Bonta.
Thank you. And thank you, A.G. Rayfield and Mays and James. Honored to stand with you once again. I want to start by acknowledging the incredible coalition of attorneys general working together to hold the federal government accountable. We're always stronger when we stand united. This is another example of that. At its core, this lawsuit is about protecting everyday Americans from the harmful effects of unlawful tariffs. President Trump's tariffs hurt families, they raise the cost of goods and make it harder for businesses to operate. California proudly is home to the fourth largest economy in the world. We're the nation's largest importer and the second largest exporter. Millions of families and businesses, large and small, and manufacturers right here in California feel the ripple effects of tariffs immediately. Higher prices in our grocery stores, higher supply costs for local manufacturers, and disruption for businesses that rely on global trade. All 39 million Californians depend on an affordable, predictable economy. And these illegal tariffs undermine all of that. Trump is trying to use an obscure law to push through tariffs that his co-equal branch of Congress, not the president alone, is supposed to authorize. Simply put, the law does not allow this, and we won't stand by while it's broken. Last year, we went to court to challenge Trump's illegal imposition of tariffs under the International Emergency Economic Powers Act, IEEPA, of 1977. Last month, the Supreme Court struck down those tariffs as unlawful, rightfully so, tracking our exact arguments in this coalition. Today, we're back for round two because instead of accepting the ruling, the president doubled down. He raised the tariffs first to 10% and then announced he'd raise them to 15% under Section 122 of the Trade Act of 1974. Again, Section 122 is an obscure law that has never before been invoked. It's never been relied on before, ever, in its 52-year history. It relies on an outdated system of currency exchange that we don't even use anymore, which means it's entirely irrelevant in this case. In fact, the president's tariffs don't meet any of the requirements of the law. In short, Section 122 doesn't grant the president the authority to impose these tariffs. He's desperately grasping at straws here. The president's rationale for these unlawful tariffs has gone from unreasonable to ridiculous. This is the 60th time since he took office that California has had to step in and take the Trump administration to court to protect our people and our economy from unlawful federal overreach. President Trump ran on the promise of making life more affordable for families, yet here he is, breaking the law to make life more expensive for Americans, literally working overtime, stretching and reaching so far as to break the law in order to raise costs for Americans. At the end of the day, for us, this isn't about political gamesmanship. It's about making sure our communities aren't paying the price for Trump's inability to take an L. Together, we'll continue to push back against unlawful federal overreach and make sure the president follows the law. When the federal government acts outside its authority, we'll be here to put a stop to it. Thank you again, and happy to pass it over to our amazing colleague, Attorney General Letitia James.
Good afternoon, everyone, and thank you to my fellow attorneys general for their continued partnership and their leadership on this case. I'm proud to stand alongside my colleagues from across the country as we take action to defend the Constitution, protect our economy, and stand up for the rule of law. Just weeks ago, the Supreme Court rejected the administration's attempt to impose sweeping tariffs without proper authority. And now the president has chosen a different route to accomplish the same unlawful, illegal, and unconstitutional goal. And that is why we are back in court. This latest attempt is nothing more than an effort to sidestep the Supreme Court and impose tariffs that the president does not have the authority to enact. And no matter how this administration tries to dress it up, the result is the same: illegal taxes that American families and businesses will be forced to pay. Tariffs drive up the cost of everyday goods. They squeeze small businesses and ultimately force consumers to pay more for groceries and clothes and other essentials. At a time when families are already facing an affordability crisis, the last thing New Yorkers need is another round of unlawful tariffs that make life even more expensive. These policies are also creating economic chaos. Businesses and state governments need stability to plan, budget, and invest. And that kind of unpredictability creates chaos for businesses, raises costs for states, and disrupts supply chains that millions of people depend on. The stability of our economy is more than just a political talking point. It is imperative to improving the daily lives of working families. And most importantly, it is foundational to our democracy. That is why we are asking the court to declare these tariffs unlawful. My office will continue to stand up for New Yorkers, defend the Constitution, and push back whenever federal power is abused. I thank you again to my colleagues for their leadership, and thank you to everyone who joined us today. But the bottom line is that the trade deficit is not a legitimate reason for imposing or invoking tariffs under Section 122. Full stop. Thank you.
Attorney General James and all the attorneys general. Like I said, we do want to open it up for questions now from reporters using the hand raise function. And again, if you could identify the outlet you were with when I call on you and unmute yourself when I call on you, that would be great. First, I want to call on Tony Rome.
Hey, I think I got it to work. All right. Hey, everybody. Thanks for doing this. I just wanted to ask a bit of a procedural question here. Given the fact that the tariffs under 122 are capped at 150 days, and that the president has signaled that they might issue some new order soon that would raise the tariff to 15%, how will you all proceed? Are you going to ask the court to halt the tariffs immediately as you argue over the merits here? And how would you address it if they do indeed raise the tariff through some new order? Thanks.
Yeah, and we'll just go ahead and maybe take it one by one. And I think this is very similar to the first tariff lawsuit. The fact of the matter is that they are unlawful to begin with. And if there's a period in time which they are unlawful for 10%, the administration will need to send repayment checks back to folks if they're collecting tariffs under 10%. Once they raise to 15%, the same analogy applies there. And so for us, it's a matter of stopping these tariffs as quickly as possible and from being implemented. I think it's important to note when we were successful in the prior lawsuit and got a stay, when we got a ruling in favor of us on the merits in the lower court, the federal government actually asked for a stay in that case. And they did it at multiple levels during the process. And when they did so, the federal government filed documents with the court that an argument of why they should have a stay, saying that they would happily repay the plaintiff's costs for the period of time that the tariffs were in place with interest. So it's very interesting right now to watch the federal government backtrack on that. And I expect that to be a very interesting point should we be successful in the lower courts and the federal government seek to administer a stay in this case.
All right. We will move on to the next question. We'll take it from Jacob Gardenswartz. And again, if you could identify the outlet you are with and perhaps identify if you have a particular attorney general who you would like to answer the question.
Hi, thanks for doing this. This is Jacob with Scripps News. I think I'd be interested in any or all of the attorneys general with us to answer these questions. First, on the new lawsuit, just wanted to ask, given that it took nearly a year to ultimately get a Supreme Court ruling on the IEPA question, which was relatively quick for Supreme Court standards, and there is that 150-day limit on the president's ability to use the Section 122, do you expect a ruling on this matter, a definitive ruling, before the president is, legislatively tracked out from being able to utilize this authority? And then secondly, on the IEPA tariff specifically, you noted the judge indicating that the administration needs to begin to return some of those refunds to businesses who paid tariffs that have now been said to be illegal. We've heard from business owners that a number are very much confused or struggling to navigate how exactly that process will go. Are any of your states considering, setting up some sort of programming clearinghouse to help business owners who did pay tariffs navigate the refund process? Thanks.
So let me begin first, and the first part of your question. This case will go to the Court of International Trade, and hopefully we will get an immediate stay or PI in regards to this case. Two, I think it's important, you talk about the 150 days, but what you do not talk about the fact that this law is anachronistic. It no longer applies in our system and our economic system. And two, I'm of the opinion that this administration, the President of the United States, conflates the balance of payment deficits with the trade deficit. And they're two distinct issues. And that is why, again, the trade deficit is not a legitimate reason for imposing tariffs under Section 122.
I would just add to all of that, the Supreme Court was very clear about its position on the level of overreach by the Trump administration on the IEEPA tariffs. Several of them cited the major questions doctrine. We quote Justice Gorsuch in our complaint on that question. And then obviously, so obviously we're hoping to get a quicker decision based on the very resounding, we thought, victory that we achieved in the Supreme Court, and based on the language of the justices themselves. And obviously we did really well in the Court of International Trade the first time. So yes, we hope that it'll go a little quicker, but as AG James mentioned, we're looking for a preliminary injunction here and a stay, at least in the near term.
And maybe I'll just add that there are parts of litigation that take time, and there are parts of litigation that move very quickly. And this coalition has at times moved for preliminary orders, temporary restraining orders, preliminary injunctions that we have sought and received within 24 hours. So the relief, and here relief could look like blocking the imposition of these unlawful tariffs, very soon, could provide immediate benefit to Americans, to businesses, and of course, to the extent there are tariffs that get imposed, and businesses and Americans are victimized by the higher prices. Just like with our first lawsuit, there's an opportunity for refunds to be provided. So relief looks like a lot of different things. Some is fast, some takes more time. Some could be preventative in stopping the imposition of the tariffs on the front end. Some could be curative, or in the form of sort of a restitution where there's a refund payment. But any way you look at it, there is no justification for these unlawful tariffs. That's why we're bringing this action.
And just really quickly to the second part of the question, which is, are any states, having a clearinghouse to kind of set up for the refund process? I'm not aware of any state that is doing that. I think the baseline for us as we think about refunds is you had more than a year where the president was unconstitutionally and unlawfully taking money out of the pockets of Americans and small businesses. It is their responsibility to figure out how to put it back in those same Americans' pockets. If they can figure out how to take tariff money, they can figure out how to get it back to us. They do not and should not put the burden on the states to foot the bill for the refunds.
Let's go to Matthew Kish next.
I'm Matthew Kish from the Oregonian. Question for Attorney General Rayfield. Why did you seek to put Oregon in the lead plaintiff position in this litigation? Thank you.
Was the exact same reason that we wanted to lead on this during the first tariffs case. When we've been traveling the state, as I mentioned, we're talking to small businesses, consumers, frankly, and seeing the impacts on a state level that these tariffs are having, the uncertainty, the unpredictability. We are a state that is trade dependent. We export more than we import. You see trade relationships being destroyed as a result of these things. Last year, we saw our revenue forecast in Oregon go down by more than $500 million, as referenced by the state economist, as a result of these tariffs. This is impacting all of us. It's the number one issue when you talk to Oregonians, Americans, right? Affordability. How do I get through the day-to-day expenses of what we're experiencing, from the utility costs all the way down to certain grocery items that you're buying in the store? So this is one of the easiest decisions that I've had as Attorney General to move forward on this.
Okay, up next, Brock. I don't want to get your last name wrong, but Brock, who has his hand raised.
No worries. Brock Rehor from Politico. Thank you all for doing this. My question is, what is the confidence level that the coalition will be able to persuade the Court of International Trade to grant an injunction? Is there any skepticism that it would, or that the appeals court or the Supreme Court would uphold an injunction?
I think we're pretty confident. Otherwise, we would not be here. The reality of the situation, again, is that the trade deficit, this is not an appropriate vehicle, not an appropriate reason for invoking the tariffs law the tariffs under Section 122. And because we were successful in the United States Supreme Court, we are 100% confident that we will be successful in the Court of International Trade.
Yeah, and I would just add to that. I mean, I think the complaint very clearly and concisely lays out why Section 122 cannot be used in the way that President Trump is attempting to do here, how absolutely, flatly illegal it is. And so it violates that section itself, in addition to, as we point out, the separation of powers. And then finally, I would add, we have more states joining us this time. So, we have I think a total of 24 states on this lawsuit. And first one was a strong one, obviously very well supported. And this one includes 2 governors. I believe the governors of Pennsylvania and Kentucky have joined us.
I might just point to 2 factors for everyone as you're kind of evaluating the terminology and kind of the history cited in the complaint. The first one is just American history. Looking at when we were under the gold standard, looking at when we started to shift away and the actually balance of payments deficit problem we had under Nixon. We were in an interim period where we went to a floating exchange where we didn't know if we were going to go back to the fixed exchange. It was actually an uncertain moment in time. That's when the statute was passed, specifically to address the issues that we experienced with that deficit under a fixed exchange, the gold standard. Then we eventually made the permanent switch to making sure that we were on this current system that we're at right now with the floating exchange. So looking at that history, seeing the intent, and then the most important words are balance of payments deficit. Balance of payments is a term of art that has been used in economics for ages, centuries. And so when you go back and look at that, it is an unmistakable term of art that does not apply to the crafty legal ways that the Trump administration is trying to use it.
Right. And I'll just add, don't be misled by the purported compliance with other aspects of Section 122, like staying below the 15% threshold, or any statements that the tariffs will only last 150 days. If you don't pass the threshold issue of there being a balance of payments deficit, which they don't, and as we've said, a balance of trade deficit is very different, then it doesn't matter if you comply with other aspects. They have not complied with the threshold requirement, the trigger, if you will, to invoke Section 122, and therefore the tariffs are unlawful.
Okay, next we're going to take a question from the chat. Dave Mason with the Center Square was having trouble with his hand raise function, and this is for AG Bonta. He is asking, how much money have the previous tariffs cost businesses in California, and how much money could the new tariffs cost the state? Do you anticipate this will go all the way to the Supreme Court?
Thank you for the question. I'm going to do a little math here, which I'm sure is going to make my team very nervous. And I'm not on safe ground here. But I think the estimates were that the prior tariffs under IEEPA cost each American $1,000 to $2,000 over the course of a year. So with 40 million Californians, that's, I think, $40 billion to $80 billion of cost to Californians. And the estimates on the cost of the new tariffs are in the $200 to $600 range per American. So you can do the math on that for 40 million Californians and what that would cost. But any way you look at it, any way you do the math and get these numbers, these are huge costs that Californians and Americans are bearing when they are screaming for more affordability, not less, for prices to be lowered, not raised, and for the President of the United States twice to act unlawfully to raise prices after promising the American people he would lower prices. I think that tells you all you need to know.
Okay, next, Balin Overstolz McNair has a question. Balin, are you still there?
I am, sorry. Still getting used to Zoom after all these years. Ballin Overstoles from KTR News. Question for AG Mays. When we talked about the IEEPA tariffs being struck down, you said Trump would have these new tariffs for the 150 days and go back to Congress, like we've heard. And at the time, not really indicating he'd be filing a lawsuit over this. Did anything change in your mind from then to joining this coalition?
Well, obviously, I didn't want to telegraph anything, and we were working on this and doing the research on this, and it's this is a process, and when my colleagues talk about the partnership that the AGs have, they're serious about that, and really led by Dan Rayfield in Oregon. But with all of our teams working together, we did the research. I think the complaint is fantastic and just really, lays out the history of this obscure Section 122 that has literally never been used by any president to levy tariffs on the American people. And we wanted to get it right too, right? It's something that we believed initially was unlawful. We knew it would have a terrible impact on our economies, on small businesses, on consumers. But we really wanted to dig in and make sure that we got the research right and that we could put forward the best possible complaint to the Court of International Trade.
Okay, up next, Doug Palmer.
Hi, thanks so much for doing this. A lot of my questions have been asked, but I was just curious. These are all either Democratic attorney generals or Democratic governors that are on the case. Did you guys reach out to any of your Republican attorney general colleagues, and did they just flat out refuse, or I just was curious if you had any conversations with them.
I think in the current political environment, it's very difficult for Republicans to join on to a case like this challenging their party's leader. We saw this in the primaries last week, where he, as the president who leads through fear, really has the ability to put sideboards on the way that some members in their party who are fearful about their political career can take on certain issues. We absolutely know that there are free trade Republicans out there. I mean, this is something, if you go back to Ronald Reagan and where he was at. So it's unquestionable that this is a policy that is, or that our actions challenging these tariffs are supported by Republicans. I think it's incredibly difficult for Republicans to step in and do that, especially when they're looking at their next primary where there might be challenge from the right. So it's a very precarious time, I think, to be a Republican in cases like these.
And I would just add, we have made it clear from the beginning that we would love to have Republican AGs join us on these lawsuits. And it's really their states that are being harmed the most when they don't join us. I've saved $1.5 billion for the state of Arizona through my 37 lawsuits. And I know all of my colleagues have numbers like that. In fact, some even bigger, given their population and the number of lawsuits that they have filed. And, as Dan said, these lawsuits in our states are being widely supported by Republicans and Democrats and independents because all of them are being harmed and they all care about our economies. And so this is probably the most bipartisan lawsuit or series now of lawsuits that we have filed on behalf of the American people. So we welcome Republican involvement in these lawsuits. We just haven't gotten any of it.
And what I would say is that AG James texts me a lot talking about how she is proud to stand up for the citizens of Texas and Florida on their behalf. And so it's wonderful to be a part of this coalition.
Let me just say that we do work in a bipartisan fashion on a wide range of issues. But in this particular space, unfortunately, we have not received any communication from our Republican colleagues. From antitrust laws to opioids to consumer laws, we work collectively and bipartisan and across the state, across the country. But unfortunately, when it comes to tariffs, there's not been any communication with our Republican colleagues. Let me also go on to say that another reason why we have decided to file this lawsuit is because the imposition of Section 122 suggested that the president not be discriminatory. And there's over 80 pages of products that have been excluded from these tariffs. And that's really critically important that individuals understand. One, that again, that it's discriminatory. Two, that it's anachronistic. And three, that has nothing to do with a trade deficit at all.
And I'll just add that the Republican AGs have shown no interest in, for California, 60 different lawsuits that we've brought. And Democratic governors with Republican AGs have shown interest to fight for their constituents, to fight for the rule of law, to make sure that they have funding that is theirs, that as Congress has appropriated it to them. But the Republican AGs have they've been just uninterested and supine. And I think they're secretly rooting for us, because when we deliver a victory and get tariffs struck down, their residents benefit, their businesses benefit, but they seemingly won't dare to stand up for the rule of law, even when they're being hurt by a president who's breaking it and harming the people in their state. So it's unfortunate, but we're happy to do this work and happy for as many Americans in whatever state they're in, blue or red, to benefit from this work.
Can I just make one last point on this? We did here in Arizona have, for instance, the Arizona Chamber of Commerce come out in support of this lawsuit and the victory that we had in this lawsuit. So, business groups are supporting us. And, if Republicans want to, certainly they could file amicus briefs in support of our lawsuits at a minimum in front of the courts.
All right. Well, it sounds like some of the attorneys general have some time constraints. So we are going to go ahead and wrap up this press conference. We thank everyone for joining us today. And if you have any questions, of course, feel free to reach out. And we're going to be sending out the filed complaint as soon as we have it to everyone. So again, thank you for joining us, and we'll talk soon.
Thanks, everyone.
AG Bonta.
Recording stopped.
AG Bonta,
Yes.
could you stay on really quick?
Yeah, talk to Dominic. Yeah.
Yes.
No problem. I'm here.
Yeah.
Sure.
Yes. Hopefully he's still there.
It looks like he might have jumped off, but I can send him a quick email.
Okay. Yeah. Yeah.
See if he'll jump back on. I can just answer him here.
Yeah. We were trying to manage that with all the other stuff.
All right, I just emailed him.
And then Marta, did you want to stop the recording?
Yep, just did.
Yeah. Okay. I feel like I wrote Dominic, stay on. Thank you for doing this.
Of course. Really great. Thank you.
Good job. I know, sorry, we don't have the webinar.
And I'm just going to put everybody else in the waiting room.
Thank you. I was going to ask you about that. Yeah. Okay.
Is my team on here?
Yeah, I don't know.
Okay. All right, I can hold. If he's not available, I can also set up a call with him if you want and answer his questions. But
yeah, he was asking, and I was like, I don't know if we want to talk about that during this call, like, because I wasn't aware. And he's like, well, I asked him if I could ask, and I'm like, oh gosh. So we were trying to.
It's completely an appropriate question. I'm happy to answer it. I know we want to stay on topic as much as possible when we have all.
Yeah, no, I didn't want to like spring that on you if it was like completely out of left field. So yeah, I was nervous to pop that in. Did you email him, Marta?